Welcome to literary and jury charge practice. Let's get started with a little warm-up, little jury charge warm-up. Ready? Here we go. Ladies and gentlemen of the jury, the written instructions now being given will be made available in the jury room during your deliberations. They must not be defaced in any way. Some of the instructions may be modified by typing or handwriting. Blanks in the printed instructions may be filled in by typing or handwriting. Also, portions of the instructions may have been deleted by lining out. You are not to be concerned with the reasons for any modifications that have been made. Also, you must disregard any deleted part of an instruction and not speculate either what it was or what is the reason for its deletion. Every part of an instruction is of equal importance. You are to be governed only by the instruction in its final form. If in these instructions any rule, direction, or idea be stated in varying ways, no emphasis thereon is intended by me, and none must be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and are to regard each in the light of all the others. The court has endeavored to give you instructions embodying all rules of law that may become necessary in guiding you to a just and lawful verdict. The applicability of some instructions will depend upon the conclusions you reach as to the facts. As to any such instruction, the fact that it has been given must not be taken as indicating an opinion of the court that it will be necessary or as to what the facts are. If an instruction applies only to a state of facts which you find does not exist, you will disregard the instruction. All right, hopefully your fingers are warmed up, and let's move on to this jury charge. Ready? Two classes of evidence are recognized and admitted in courts of law, upon either or both of which, if adequately convincing, juries may lawfully find an accused guilty of crime. One is direct evidence and the other is circumstantial. Direct evidence of the commission of a crime consists of the testimony of every witness who, with any of his own physical senses, perceived any of the conduct constituting the crime, and which testimony relates what thus was perceived. All other evidence admitted in a trial is circumstantial, and insofar as it shows any acts, declarations, conditions, or other circumstances tending to prove or disprove a crime in question, or tending to connect or not connect the defendant with the commission of such a crime, it may be considered by you in arriving at a verdict. The law makes no distinction between circumstantial evidence and direct evidence as to the degree or proof required for a conviction, but respects each for such convincing force as it may carry and accepts each as a reasonable method of proof. Either will support a verdict of guilty if it carries the convincing quality required by law as stated in these instructions. If the evidence in a criminal case as to any particular count is susceptible of two constructions or interpretations, each of which appears to you to be reasonable and one of which points to the guilt of a defendant and the other to his innocence, it is your duty under the law to adopt that interpretation which will admit of a defendant's innocence and reject that which points to his guilt. You will notice that this rule applies only when both of the two possible opposing conclusions appear to you to be reasonable. If, on the other hand, one of the possible conclusions should appear to you to be reasonable and the other to be unreasonable, it would be your duty to adhere to the reasonable deduction and to reject the unreasonable, bearing in mind, however, that even if the reasonable deduction points to a defendant's guilt, the entire proof must carry the convincing force required by law to support a verdict of guilty. If two reasonable inferences, one of guilt and one of innocence, may be drawn from a chain of circumstances or a necessary link in such a chain is not proven beyond a reasonable doubt, then a defendant cannot be convicted thereon. But all that is required to convict is this: if the testimony in a case is sufficient to convince the jury beyond a reasonable doubt and to a moral certainty that the defendant did commit the crime charged, then it is the duty of the jury to convict, although the facts may be surrounded in a degree by some possible or fanciful doubt, surmise, or conjecture not arising from a consideration of the evidence. But if a reasonable explanation or construction compatible with the innocence of the defendant may be drawn from such evidence, then the jury must adopt the interpretation which would admit of the defendant's innocence. All right, now we'll try some literary material. Ready? I was born in Arkansas, my brother in Tennessee, my sister in North Carolina, and my mother and father in Michigan and Minnesota. My parents met in Georgia and got married in South Carolina. They first lived in Kentucky, but then they moved to Texas. We lived in Iowa, Louisiana, and Mississippi. When I was 10, I visited my aunt in Virginia. The following summer, I went to camp in West Virginia. My brother and sister stayed with our grandparents in Ohio. When I was 12, my parents took us to Connecticut during the fall, where we saw the leaves turn color. We were in New Hampshire, Massachusetts, and Rhode Island also. When I was 16, I worked for a company in New Jersey. This company bought parts in Oregon, Pennsylvania, Utah, and Wisconsin. The products were sold in North Dakota, South Dakota, Maryland, and Vermont. The company sent sales representatives to New Mexico, Nevada, Colorado, and Iowa. I graduated from school in Washington. My first job was in Arizona. The company I worked for had main offices in Florida and California. There were also offices in New Mexico, Maine, Alabama, and Delaware. Eventually, I moved to New York, where I lived for 4 years. Then I took a vacation in Hawaii. I returned but had to take a flight that made stops in Kansas and Nebraska. During my absence, my employer had gotten accounts in Alaska, Missouri, and Iowa, and I was very happy to hear it. My sister moved to Montana and my brother moved to Oklahoma. The following year, I moved to Illinois. That didn't suit me, so then I tried Idaho and Wyoming and found that I really liked the atmosphere in the West. I particularly liked the feeling in Montana and the northern part of Wyoming around Cody and Sheridan. good practice on states. All right. Let's get back to a little jury charge practice. And this jury charge is a criminal jury charge. Ready? Mr. Foreman and gentlemen of the jury, you have been called to court to render a very important service to your community. No other public service requires a greater degree of intelligence, fairness, patience, integrity, and courage. And yet, unfortunately, as we all recognize, none is so poorly compensated in monetary terms. Your satisfaction must come from the fact that your conscientious performance of this most important duty will help in a very effective and dramatic way to keep alive this spirit of equal justice under the law, which we feel is the distinguishing mark of our form of government, and which is the greatest gift that any government can give to its people. This case, like every other criminal case, is very important to the people of this state. It is also very important to these defendants. The law requires that you give equal consideration to both. It is my obligation to talk to you about the law as it applies to the facts of this case, so that you may know exactly what it is that law requires of you. Under the administration of criminal law, every person charged with the commission of a crime and who has been indicated by a grand jury of this county is entitled to a trial by jury. The proceeding is commenced with an indictment is found against the defendants. An indictment is a written accusation by a grand jury charging a defendant with the commission of a crime. It has no probative force. It is not evidence. It carries no implication or suspicion of guilt. When an indictment is returned against a person, he is required to appear and answer to the charges which have been proffered against him. This is done by interposing a plea of not guilty. All right, now some more literary material. And this is one we had started previously, and it's called Most Simple Appears Too Simple. Ready? Judicial and freelance reporters have talents of their own. They are writing, preserving, real-timing for judges and officials, often producing a transcript. Their records will assist civil and criminal parties in lawsuits to defend and or prosecute. Each motion, each event, each action is simply different. Court reporters preserve the State of the Union and the State of the State addresses, in addition to multiple country, municipal, state, and national government proceedings. Many of us have operated under a hush clause, confidentiality contracts, providing on-site and remote real-time technology, pushing verbatim text. We just can't tell you anything about it, really. Cart providers use their skills to assist with equal accommodations to simply produce records or to fulfill a specific customized request. And students, many are focused on the idea of, I just want to get out of here. I remember saying those words. Many say with raised voice, just tell me what to do so I can get out of here. When I hear how long students have sat in a chair with consistent test scores, I have whined. How does a student progress? Simply, I know the bucket containing goals and wishes is different for everyone. When the most simple method to tweak a stroke, to move toward a goal, and to correctly stroke a word, even when how to look up how to write that word is to simply look within a theory book, we simply move forward. The tenacity of this profession is outstanding. We do not remain bogged down by difficulty, do we? Judicial reporters, freelance reporters, cart providers, captioners, court reporting instructors, and students are focused personalities. I began this column with this thought. The weak point is finding a direction. When we focus our attention on simplicity, we learn new lessons. In a never-ending quest, we simply move our goals. We find a direction, simply moving to a better place. Yes, we most simply do. Back to some jury charge practice. And the subject of this jury charge is income tax evasion. Ready? Evidence, if any, that a defendant on one or more occasions other than from the witness stand made false, contradictory, or misleading statements concerning the charge against him which is now being tried may be considered by the jury as a circumstance tending to prove a consciousness of guilt, but is not sufficient of itself to prove guilt. The weight to be given such evidence and the significance, if any, to be attached to it are matters for the jury to determine. A jury must view with caution all evidence, if any, of the oral admissions of the defendant made out of court. The direct evidence of one witness who is entitled to full credit is sufficient proof of any fact in this case. You are not bound to decide in conformity with the declarations of any number of witnesses which do not produce conviction in your minds against a lesser number or against a presumption of law or other evidence which appeals to your mind with more convincing force. This rule of law does not mean that you are at liberty to disregard the testimony of the greater number of witnesses merely from caprice or prejudice or from a desire to favor one side as against the other. It does mean you are not to decide on your own by the simple process of counting the number of witnesses who have testified upon the opposing sides. It means that the final test is not in the relative number of witnesses, but in the relative convincing force of the evidence. The rules of evidence ordinarily do not permit the opinion of a witness to be received as evidence. An exception to this rule exists in the case of a witness who by education, study, and experience has become an expert in any science, art, or profession, and may give his opinion as to any such matter in which he is versed and which is material to the case. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight. You may reject it if, in your judgment, the reasons given for it are unsound. The jury are the sole and exclusive judges of the effect and value of the evidence addressed to them and of the credibility of the witnesses who have testified in the case. The character of the witnesses, as shown by the evidence, should be taken into consideration, for the purpose of determining their credibility, whether or not they have spoken the truth. The jury may scrutinize the manners of the witnesses while on the stand and may consider their relations to the case, if any, and also their degree of intelligence. A witness is presumed to speak the truth. This presumption, however, may be repelled by the manner in which he testified, by his interest in the case, if any, or by his bias or prejudice, if any, or by contradictory evidence. A witness may be impeached by contradictory evidence or by evidence that on some former occasion he made statements or contradicted himself in a manner inconsistent with his present testimony. Whether or not you believe any particular witness who has testified in this case and the weight that is to be attached to his testimony is a matter for your judgment entirely. It is your duty to consider the testimony of the witnesses, to weigh it, to analyze it, and to carefully scrutinize it. You should take into consideration whether the testimony of the witness is reasonable or unreasonable. You have a right to compare the statements of the witness on the one hand with the actions and conduct of the witness upon the other. All right, that will conclude our literary and jury charge practice.